For delivery of order item 8.
Heard Mr. M.K. Hussain, learned counsel for the petitioner. Also heard Mr. D. Nath, learned senior advocate for the government of Assam. For the advocate, the government of Assam for the respondents. The petitioner, Sahar Banu, has instituted WPC 3363/2017 on an allegation that on the premises that her deceased husband Idris Ali was apprehended by police personnel of Dhing police station along with STF Jokhalabanda. What is STF?
Special Task Force.
Special
Task Force.
Special Task Force Likiwa, along with Special Task Force Jokhalabanda. Not arrested, apprehended, arrested. In connection with Dhing PS case number 322/2016. Dhing 22 is under which section?
This was not.
Sorry.
PS case was not annexed by me, Lordship.
No. PS case was registered under which penal offenses?
Lordship, 25(1) capital A of Arms Act.
Was under 25.
1 capital A Arms Act. Read with
25 bracket 1.
25 bracket 1 bracket capital A, Lordship. Read with section 51 1A capital A of the Wildlife Protection Act, Lordship.
Section 2. These are the only two sections. But while in custody of the police authorities, the husband of the petitioner died on 25/8/2016. In the circumstance, this petition is instituted claiming for appropriate compensation to the family members of the deceased by raising an allegation that he died due to internal injuries inflicted upon him by the police personnel of Dhing police station along with the Special Task Force Jokhalabanda. And further, as because of negligence on the part of the jail authorities. In response thereof, the respondents have filed an affidavit in opposition, wherein a death report of the husband of the petitioner, Muhammad Idris Ali, under the signature of the Medical and Health Officer, Central Jail, Nagaon, has been annexed as Annexure 2. The death report is extracted as below. Do you have a soft copy of this page? No, I think you have a soft copy of this page.
Of the death report.
Of the death report. If you have, please give it. Otherwise, you'll have to type out the whole thing again.
I have to, this is a typed copy. I'll have to collect.
Just, if it is available, please give it. Otherwise, it's okay.
That's okay.
In the affidavit in opposition, the post-mortem report of Muhammad Idris Ali is also annexed. Wherein, in respect of the pericardium stroke heart stroke vessels, the following is provided. Page 34. He reported as a hemorrhagic, slightly blackish area. It took out for দিব। In the post-mortem report, the opinion of the assistant surgeon, stroke assistant surgeon, as to the cause of death is provided as extracted. It will page 34 or say. Based upon the death report provided by the medical authority, read conjointly with the provisions of the post-mortem report, a stand is taken by the respondent authorities that the death caused to the deceased husband of the petitioner cannot be said because of any excess or beating being inflicted by the police authorities while he was in their custody. Mr. D. Nath, learned Senegal advocate, strenuously argues that the medical report as well as the post-mortem report would indicate that it was more of a case of a natural death rather than a death being caused by inflicting any injuries on the person arrested by the police or the jail authorities. A reading of the death report of the deceased would make it discernible that on 23/8/2016, he was examined by the Medical and Health Officer, Central Jail, Nagaon, on the symptoms that prevailed, that the deceased was having pain and swelling over both hips, legs and body. The chest was found to be clear, but the medical authority diagnosed noticed certain abdominal pain with distended. What do you mean by that? Abdominal pain with distended. One inverted comma, did you go? Mr. Nath, any meaning of that? Abdominal pain with distended. Accordingly,
I'll check.
the deceased was provided certain medications, a reading of which shows that certain medications in the nature of antacids were also provided. On 24/8/2016, the medical authority, same medical authority, again examined the deceased husband of the petitioner and continued with the earlier treatment with an observation that he was doing well on 24/5. It must have been 24/8, on 24/8/2016. On 25/8/2016, the medical authority went to the Central Jail, Nagaon at about 5:35 a.m. and examined the deceased husband of the petitioner and had given him certain treatment and referred him to the BP Civil Hospital for emergency OPD at 6:10 a.m. The symptoms noticed amongst others were pain in abdomen and distended, chest pain and respiratory difficulty, systematic examination with CNS normal and chest Crepitation. What is crepitation? Is it a medical term?
Medical term.
কোনটো?
Yes, medical.
Crepitation মানে কালির কাগজ বেলেগ and chest crepitation. Accordingly, in the hospital itself, the deceased husband or the petitioner was provided certain further medications. Upon being taken to the hospital, the deceased husband of the petitioner died at 6:30 a.m. on 25/8/2016 in the BP hospital, Nagaon. In the process, a post-mortem examination was also done on the body of the deceased husband, the petitioner. The Medical and Health Officer, Central Jail, Nagaon, in his death report, provides that as per the post-mortem report, the cause of death was due to cardiomegaly, that is a result of myocardial infarction. And further, that the post-mortem was done by the Deputy Superintendent of BP Hospital, Nagaon. From the medical death report, as provided by the Medical and Health Officer, Central Jail, Nagaon, as well as the post-mortem examination, post-mortem report, which remains uncontroverted by either of the parties in any manner, the death of the husband of the petitioner apparently took place because of cardiomegaly, which was a result of myocardial infarction. Which cardiomegaly, under the medical terms, is understood to be a medical condition in which the heart becomes enlarged and is also commonly referred as enlarged heart, where, as because of the underlying conditions of the person, the heart is made to work harder. Cardiomegaly is also, in medical terms, understood to be a serious condition which can result in congestive heart failure. Some of the signs and symptoms associated with the medical condition cardiomegaly are, as per the materials produced before the court, megaly, as per the medicals produced before the court, are. Out of the aforementioned signs and symptoms usually associated with the medical condition cardiomegaly, we have noticed that the deceased husband of the petitioner was found to be having abdominal pain, which again would have a thin line of difference with that of chest pain, semicolon. The deceased has been a petitioner on 23/8/2016 itself was found to be having swelling on his pain and swelling on his both hips and legs, as well as body. Which symptoms were also noticed on 25/8/2016 when the medical authority examined the deceased husband or petitioner at 5:35 a.m. with the symptoms being more pronounced in respect of chest pain and respiratory difficulty. If the medical condition cardiomegaly is associated with the aforesaid symptoms, and many such symptoms were noticed by the medical authority to be prevailing in respect of the deceased husband of the petitioner, when he was examined on 23/8/2016, 24/8/2016, and 25/8/2016, a question would naturally arise as to why the medical authority who had examined the deceased husband of petitioner could not apply its medical mind and arrived at some kind of a diagnosis that there is a possibility that it is a possibility of being a case of cardiomegaly, and accordingly immediately refer him for the specialized medical treatment and diagnosis. Even if we conclude that no materials are available on record that the medical condition that the deceased husband or the petitioner was having was caused because of any beating or application of any external force by the police authorities while he was in the jail custody. But when he was reporting adverse medical condition and was being attended by the medical authority of the jail, it is also reasonably expected that the medical authority would would give a more detailed application of mind. And if the medical condition otherwise would appear to be a serious medical condition which requires specialized treatment, the law also requires that such treatment should be meted to the person. I'm not trying to do something. Under trial of the right to The Supreme Court, in its judgment, rendered in Kerala Union of Working Journalists versus Union of Indian Others, dated 28/4/2021, had provided as extracted a line to the pink underline, pink underline. The Supreme Court has provided that the right to life would also unconditionally embrace even an under trial, where a right to life would also include the right to be provided with adequate and appropriate medical treatment whenever it is so required. The Constitution Bench of the Supreme Court, in its judgment rendered in Nilavati Behera Srimati alias Lalita versus the state of Odisha and others reported in 1993 to STC 726 in paragraph 31 provided as extracted. A pronouncement of the Supreme Court in para 31 of Nilavati Behera makes it apparent that convicts, prisoners, or under trials are not denuded of their fundamental rights under Article 21, which, as per the law laid down by the Supreme Court in some of the later judgments, also includes the right to receive adequate and appropriate medical treatment. The Supreme Court is explicit in its provision that the precious right guaranteed under Article 21 of the Constitution of India cannot be denied to convicts under trials or other prisoners in custody, except according to procedure established by law. The Supreme Court further provides that the wrongdoer is accountable and the state is responsible if the person in custody of the police is deprived of his life, except according to the procedure established by law. By following the proposition laid down by the Supreme Court in paragraph 31 of its judgment in Nilavati Behera, in an instant case, it is noticed that the fundamental right of the deceased husband of the petitioner to right to life, which also includes the right to receive and be provided with adequate and appropriate medical treatment while he was in the custody of the jail authorities, had been violated to the extent that although his underlying medical conditions indicated that contain certain symptoms which are also symptoms applicable to the medical condition cardiomegaly, it was an error of judgment, medical judgment on the part of the medical authority who had examined him on 23/8/2016, 24/8, as well as on 25, not to have immediately referred him for specialized medical treatment for the medical condition. It is in this respect that we find that there was an aberration of the fundamental right of the deceased husband of the petitioner. Where are the three notifications, Mr. Nutt? The two notifications for complaint.
Even
Copy of the. In paragraph 35 of his pronouncement, in paragraph 35 of its pronouncement in Nilavati Behera Supra, the Supreme Court had also provided that in the event there is any violation of the fundamental right of a the word is convict of a convict, prisoner, or under trial, comma, which results in comma. It would be for the state authorities to compensate for such violation of the fundamental right, notwithstanding the right of the citizen to a remedy by way of civil suit, criminal proceeding, etc. The relevant portion of the para 35 is also extracted. For the purpose of compensation, we have noticed that there is a notification issued by the Revenue and Disaster Management Department Relief and Rehabilitation Branch of the Government of Assam, dated 15/11/2014, which provides for an ex gratia payment to the next in kin of person killed due to accident in public places or in public carriers, other than killed by extremists, terrorists, miscreants, and due to firing security forces, which had been quantified to be rupees 2 lakhs. I think it's enhanced to 3 lakhs now.
Latest notification, Lordship, I have given 5 lakh, Lordship. I have
Where is your latest?
from the Home Department.
That is by the Home Department.
That is different.
That is.
Then you have to go for more inquiry, how the death was caused.
Lordship.
A relief and rehabilitation.
This is remains a 2 or of late it was increased to 3.
15, Lordship is taking up the 15/11 notification.
15/11, 2014.
15/11/14.
Did a later one, did it increase to 3 lakhs on the same count? Just check up. Mhm. This is again victim compensation. You are not a victim,
I'm
you are an accused.
Lordship.
So you can't bring in all kind of provisions from wherever you feel like. We have noticed that the amount of rupees 2 lakh is provided by the Government of Assam in case of any death that may happen in any accident in any public place. The jail premises or the premises, the jail premises where the happening took place would definitely have to be understood to be a public place. Jail is a public place. It cannot be nobody's house, the public place. Although a question may remain as to where the final death ultimately took place, that is in the jail premises or in the hospital. But be that as it may, if we consider the death to have taken in a public place, the husband of the petitioner in any view of the matter would have been entitled to a compensation of rupees 2 lakhs. By the same notification, it is provided that ex gratia payment amounting rupees 5 lakhs is payable to the next of kin of such persons who were killed in extremist, terrorist, killed by extremist terrorists or by miscreants, semicolon, or during communal, ethnic, or group clashes, semicolon, or due to firing of security forces, etc. We are not proceeding in the manner that the death was caused due to any of the reasons provided in the notification of 15/11/2014 as regards the ex gratia payment of rupees 5 lakhs for the acts on the part of either extremist terrorist miscreants or communal ethnic group clash or due to firing of security forces, but merely refer to the state provision for the purpose of arriving at the quantum of compensation that may be payable. Although the death may not have been caused because of any extremist terrorism or miscreant violence, or because of communal ethnic or group clashes, or because of any firing of the police forces, or because of any act attributable to the police forces. But the deaths can also be construed to have been caused as because a timely, appropriate, and adequate medical facility could not be provided to the deceased husband of the petitioner because of an error of judgment on the part of the medical authorities regarding his underlying medical conditions. From such point of view, the respondents to the Home Department will pay. Respondents to the Home Department of the Government of Assam is directed to pay an amount of rupees 5 lakhs as compensation to the writ petitioner, who is admittedly the wife of the deceased husband and would have to be understood to be the best qualified next of kin of the deceased person.
That's for number 2 and 5.
2 and 5. The payment be made within a period of 1 month from the date of receipt of the certificate of your bill. Writ petition allowed as indicated above.
Lordship may give 2 months time.
2 months.
Some process next time. How like?
People like you.
All right.
Yes. We clarified that we are invoking that clause not for attributing any cause, but to extract the quantum.
The analogy, Lordship has
To extract the quantum.
Lordship. How like?
Item 1 and 2 for admission.
15/11/2014 is the latest. That is the up to
It's
date.
not increased. Anyway,
That
we
is
have
Not-
not gone for that.
How like?
Couldn't have. 97.
I understand, my lord. I was told day before yesterday by Sri H.R.A.
We
Chaudhary.
have invited all learned counsel, whoever would like to address the court.
Oh,
We have not requested anybody
Acha, acha.
specific. On the issue, what will be the existing right and rights of a person who is declared to be a foreigner? What rights he will not have, what rights he will have?
yeah.
We want to decide that issue. And we would like to have the views of
Whoever is.
whoever is interested to issue the address on the issue. If you are interested, you are welcome, we'll hear it. If you're not interested.
No, I am interested in the sense, whether day before yesterday or.
But
I was
the
informed.
issue is confined only to that.
Or only to the rights of the
And
foreigner.
Mr. H.R.A. Chaudhary had referred to your name, and we expressed our view that everybody is welcome.
But
it's
if
up to you.
your lordship gives you some time.
No, time it cannot be given. We have, because day before was the second day of the hearing of this issue.
Oh,
It's been continuing since earlier, and today we intend to go ahead with it.
I could not lay my hands to the different books.
It's up to you. If you want to avail, you are free to do so. But we are not compelling anybody to address, nor
No,
we are
I
preventing anybody
understand.
from addressing. It's just an open invitation. Whosoever is willing, they can,
And-
will hear.
But in that case, my lord, I'm sorry, my lord, I will not be able to address your lordship on that issue. Right today.
But your valuable experience and knowledge would have been helpful.
But I know about Article 21 and that your lordship knows it. Yes.
Sorry.
Article 21,
It's-
that's right, that your lordship knows it. But I have to, in that case, what do I have to?
We'll hear in full, whosoever wants to address in whatever manner. We also requested State of Assam, also the central government, everyone. We'll have everybody's view and then take a call. If the proceeding spills over to the next day, you can keep track. If you want, you are still welcome.
I take my opportunity. madam.
But we don't adjourn.
Your lordship may hear other concerns, my lord, and if it spills over, madam, then I will opportunity to. Much appreciated.
Your valuable submissions are always a welcome.
But I could not lay my hands to the different subjects and the matter. I have collected some materials only yesterday, last night, but I could not go through it.
Okay. Did you have we want the list for some purpose?
My lord.
No, Mr. Das, it's a different issue. There are a number of sub-issues within the issues. It's a different one. Yes, Mr. Hendrik?
So, my lord, that one officers has not come.
Huh.
My lord,
No, we just want the number of villages that were there in the decade 1960 and as on today. And we want a complete list. Because this you must be having, because you definitely maintain accounts of your revenue receipts.
lordship, my lord,
If there is a revenue village, you are getting revenue payment. Not just in numbers, a list.
lordship. And
The-
my lord, that, my
A
lord,
list means the name of the villages.
lordship, that list, my lord, they have to collect from the district wise. lordship. So, my lord, all the records have been maintained by the deputy commissioner, under the deputy commissioner.
No, bring it.
Custody of the-
How long will you need?
Uh,
But we can't give you a long time.
lordship, he told me that there are 15 days which will be.
No,
required.
15 days is too long.
10 days, lordship.
15 hours is good enough.
My lord, they have to collect for all over the Assam.
You do it.
lordship.
You already see, Mr. Handigan, the officer, we passed this order about 15 days back. Requiring these requirements, but nobody acted on it. So on the last occasion, we had to take a more stricter view that provide the information in course of the day. We have to, because if you don't respond when the appropriate time is given. Now, there should not be much of a difficulty. These are supposed to be records almost available with the department.
My lord, that.
You don't have to collect so much. Every deputy commissioner must be knowing how many villages, what are the name of the villages within his district. There are 32 districts, I suppose,
32,
34, 32, whatever it is,
30.
whatever it is. So 32 deputy commissioners will be acting individually in their respective districts. He
Sure.
doesn't need much time. And 32 will transmit the information to the secretariat here. And the secretariat will provide us. Why do you need so much of time? If we apply the same method like the other day, it can be given today also.
My lord, that list, lordship has to be. required.
It's nothing difficult, Mr. Handy. Had it been difficult, we are also reasonable, we know. It's not difficult. If a deputy commissioner does not know from where he is collecting the land revenue, then it's a very sad state of affair. He should be knowing. The records are in his office. He has to depute one official to find out. How long does it take? Every district must be having about 500 to 600 villages. If the total number is 18,000 and there are 30 odd districts,
18,000.
so it will be about 600 villages on the average in every district. How much time you need to write the names of those villages?
And all the name of the villages also, no?
Only the name of the villages. If we need more information, we'll definitely,
In the year 1962, my lord, till date,
not till date.
only in the 1960.
What existed as on 1960 and what is the present state?
Lordship. Lordship, as your lordship give some time, my lord.
Not sometime. I think
By tomorrow.
if you allow my court staff to handle your records, he'll find it out in 2 hours. We produce it before the
They
court.
have to, my lord, inform the, my lord, the deputy. commissioner.
Nothing. Send a flash message. How long you take? Deputy commissioner, he's the head of the district. He's always available in communication. He will just depute an office. Mr. Handy, if you ask us that give us the name of the writ petitioners of the first 500 writ petitions filed today, how long will the High Court take? Within 5 minutes, you'll get the information.
Lordship.
Similarly, we are asking from how many villages you are getting your revenue. Give us the names of those villages. Why do you need so much of time? Tomorrow, make an attempt by tomorrow,
Lordship,
because we'll continue this hearing tomorrow also. By tomorrow, please make an attempt.
tomorrow,
If you need more information, we'll give you time.
Lordship, whatever he will collect. madam,
Ah,
I will-
Only the names, I don't think you need so much of time.
Lordship, he will-
Instruct all the deputy commissioners, they must be having this data almost ready, maybe with them. They just extract it out and send it to you, that's all. Yes,
Lordship, tomorrow.
because we'll continue this hearing anyway tomorrow. Just, we have to look at something.
If tomorrow, if you, my lord, that's no, my lord, that at two lordship, I can.
Sorry.
At two lordship.
At 3 also, doesn't matter.
Obliged.
Who was conducting the hearing, Mr. Hamad? I think you were leading the argument earlier.
Yeah, I was there.
Sorry,
I was there already.
you want to start or Mr. Bhuyan will start today?
He may start, but his item is.
Mr. Bhuyan will start.
Lordship, it will, no, but can he go?
Yeah, you can go. Ask him to be in contact with you. If you need more information, we'll definitely
Not-
pass the message.
Lordship, may I please, your Lordship?
What will happen to the man who is declared? Don't argue on anything else. Don't put in any political agenda. Don't put in any sentimental agenda. Put it under the law, what they are entitled, what they are not entitled. That's all. We are just confining a hearing only to that aspect.
Lordship, in this case, defense side examined 3 witnesses.
Sorry,
Defense side examined 3 witnesses.
we are not on the hearing of your matter.
PW1 herself and PW2. PW2 is the school.
Mr.
headmaster.
Mulya, please explain this, Mr. Bhuyan.
My lord, your lordship has indicated on the last opinion itself that here is a case where he was earlier declared already a foreigner by the tribunal.
No,
I'm
we have
coming.
already conducted his hearing whether he is a foreigner or
That's
not.
what I'm saying, man.
And some tentative conclusion was
Yes.
arrived. Today, purpose of this hearing is what will happen to these people.
And what are the rights of a person who is.
Not whether you are a foreigner or not, we are not concerned. We'll hear you separately for that. If necessary, we'll list your case again. But on the last date, you failed to establish that you are a foreigner. You are not a foreigner. So don't repeat that once again. Now confine your argument. Suppose you are a foreigner, what rights you are entitled, what rights you will not be entitled. Please confine to that.
But my lord, so far record is concerned, he is not a foreigner.
Delete item number 1. Yes, we hear now next item. You're disturbing the hearing. We'll hear you separately. Yes. Want to delete for you. It will be listed again separately. Yes, Mr. Hamad. Only on the issue of once you are declared, what will happen to you?
To start my arguments, my lord.
Hmm.
I'd like to.
I think you have already started an argument.
Yes,
Other
for
day,
today,
yeah.
my lord,
Yes.
I'd like to, my lord, place the 30 articles of, my lord, adopted by the, my lord, UDHR, my lord, Universal Declaration of Human Rights.
Mhm, so,
Oh. Two. Among the
Item 1, 2, pass an order, it will be listed next week. Later, deal. Or when separated from this.
There are 30 articles, my lord, which were, my lord, passed by the, my lord, Universal Declaration of Human Rights, my lord. And India is also, my lord, signatory of the UDHR, my lord. Lordship will kindly have a, my lord, meticulous perusal of all the articles, my lord.
I'm sorry, let us read the whole thing, what it provides,
My lord.
and which other provisions you
May I
want to
read?
rely on.
Right from the preamble, my lord. Very first page, my lord.
So you want to base mainly on this Universal Declaration of Human Rights.
Yes, my lord, and in fact, my lord, our constitution.
No.
my lord, well,
You want to base your arguments on this Universal Declaration of Human Rights, or you want to rely on some further provisions?
Along with-
Provisions under
along
the
with-
Constitution, provisions under some statutory law.
Provisions of constitutions also there, my lord, are also there. I'll place it, my lord.
So why don't you begin with the Constitution then,
Right.
instead of beginning with the international law of the human rights?
Right.
Begin with the Constitution. Let us see what our Constitution provides.
Now, there are some article, my lord, which I have,
Mm.
would like to produce, my lord. This is from, my lord, journalsofindia.com. Another article, my lord.
And this Universal Declaration of Human Rights,
Right.
whether it is universally applicable in the manner it is provided, or because of some local municipal laws of respective countries, there are some restrictions on it. How do you read? How do you read the Universal Declaration of Human Rights? It is an equally applicable to every human being in this earth, planet Earth. Or these provisions of this declaration are to some extent also constricted and restricted as per the local laws of the individual countries. Because if you carefully read all the articles of this declaration, if it has to be given its meaning with complete spirit and letter to each and every word, then the international boundaries will have to be taken away. You know that song by John Lennon? Have you heard one song by that famous artist John Lennon? Especially the second paragraph, second stanza of that song. Imagine there is no country. That's the beginning of the line. We can't accept, possibly can't accept that situation because the world is such, it is divided into countries. Countries are having their international borders. So as such, to make it that by this Universal Human Declaration, it's free for everyone to go everywhere. Especially that is the second line of that stanza, second stanza of the John Lennon song. There should not be any boundary anywhere. Whoever wants to go, wherever you are free to go. But that's an utopian situation. But that's not an existing situation. So possibly these declarations will have to be read in the context of the local and municipal laws of the respective countries.
regarding the fundamental rights of foreigners, my lord, as I have, my lord, handed over the, my lord, the new article, my lord. First, will kindly have a look, my lord.
If you give me articles, you have to give me every day. We don't have the Asen Agor dia to. Let's see. Agor. Yes. Item 9. You do item 9 this is. What's your?
I have handed over just now. Just-
Anyway, start. So you want to start with Article 14. Article 14 was the first provision of that article we have given,
Yes, my lord.
which according to that author, some panda or something,
Yes, my lord. Panda was there.
that it is applicable. Now, Article 14 has hundreds and thousands of facets. Is everything applicable? Or some of them are applicable, some are not applicable? And if applicable, how and in what manner it is applicable?
There are certain judgments, my lord. Those have distinguished, my lord, the rights to be enjoyed by, my lord, citizen of this country as
No,
regards.
we understand.
Well,
We follow those judgments and also accept the situation that Article 14 is applicable to foreigners. Let us understand it is applicable. Don't go into that debate. In what manner it is applicable? Because Article 14 will have thousands of facets. Do you mean to say that each and every facet of Article 14 is applicable?
No.
Or some facets will be applicable, some will be inapplicable? What is your submission?
In my submission, my lord, Article 14, my lord, will not conclusively applicable in respect of those people who have been declared to be non-citizens or foreigner. in this
Means
country.
the entire thing will not be applicable.
Not at all, my lord. Totally it will not be applicable. But if we distinguish, my lord, the rights, my lord, to be enjoyed by a foreigner or a non-citizen, my lord, some of the, my lord, applications, my lord, should have been there in respect of, you know, the declared foreigner also, my lord.
Some will be applicable. That's what we are trying to hear from you. Which will be applicable and which will not be applicable. As you submit, whatever is not applicable, we'll delete the applicability of those from this category of people. And whatever is applicable, we direct them to respect it, provide it.
Article 14 speaks about right to equality and equal protection in the eye of law, my lord. That is the basic, my lord, idea of-
What is the opening line of Article 14? Please read.
my lord.
Article 14, what is the provision? Article 14.
My lord, Article 14 speaks about, my lord, equality before law, my lord. The state shall not deny to any person equality before the law
Just a minute. Equality before the law and
or the equal protection of the laws.
equal protection of law.
Yes, within the territory of India.
So what do you understand by the expression equality before the law?
My humble understanding, my lord, regarding, my lord, equality before law is that, my lord, everyone should be treated equally, my lord.
No. This is the one of the most misunderstood article in the Constitution. Right to equality. So somehow equality before the law and equal protection of the law has now in common parlance is understood to be right to equality. So all of us are equal. What I am getting, you'll also get, what you are getting, I'll also get. This is understood to be because the provision has been converted to right to equality. Ask any person, what is Article 14, right to equality? But actual provision is equality before the law and equal protection of law.
Yes.
It's not right to equality. So now what is equality before the law and what is equal protection of law? Find out, there are judgments of the Supreme Court explaining both the facets.
Find out.
Now, if you understand Article 14 to be right to equality, and now you rely on the Universal Human Rights Declaration. A foreigner is also a human being, the citizen is also a human being. So now Article 14 comes in, right to equality. Whatever the citizen is entitled, the foreigner is also entitled. Can you sustain this argument?
No, not.
Why not? Both are humans.
Both are human.
You started with human rights. And you everybody understand Article 14 to be right to equality. Means we all are equal. Whatever you are getting, I am also getting. So where is the distinction between a foreigner and a citizen? So the foreigner as a human being is also entitled to everything a citizen is entitled. Why we cannot understand it in that manner? Let me make the problem easy for you.
Mine,
Perhaps the question is little difficult.
mine. Legal answer.
When you say equality before the law, means whatever law is applicable. Okay. It cannot be before the law which is not applicable. So now find out what are the laws applicable to a citizen and what are the laws not applicable to a foreigner. And what are the laws applicable to both. Once you find it out, this is the purpose of this proceeding. Then you apply Article 14, equality before the law. And also equal protection of the law, of those laws. So today, foreigner X is giving certain benefits. Understanding to be the interpretation of the law which provides him that benefit. Foreigner Y is not provided that benefit. Foreigner Y can come to the court and say that give me back my equality before the equal protection of law. The other foreigner X is given this one, interpreting the law to be this. I am not given, I am also entitled to it. There 14 will lie, definitely. So you'll be right in saying that Article 14 will be applicable even to a foreigner. Please continue.
My lord, regarding, my lord, the equality before law, my lord. My lord, what my humble understanding is that, my lord, the second part of the, my lord, definition of this particular article, my lord. My lord, that is, my lord, the equal protection of the laws within the territory of India.
Yes,
In my humble submission, my lord, be it a, my lord, citizen of this country, my lord, or a foreigner, my lord, everybody needs a human approach, my lord.
no one is denying that.
My lord. Therefore, my lord, the second part. I
That's why we
categorically-
started the hearing.
My lord.
Now within the realm of a human approach, what is included and what is not included? We want to know precisely that. It's nobody's case that if he were a foreigner, tie him upside down in a tree. It's nothing like that. Being a foreigner, he'll be entitled to something. Being a foreigner, he may not be entitled to something which otherwise a citizen may be entitled. So just find out your entitlements, that's all.
Regarding the, my lord, the judgments of regarding, my lord, equal protection of laws, my lord.
Equal protection of law.
Law, my lord. Be it a, my lord, foreigner or a citizen of this country, my lord. I'll try to find out the judgments of the apex court, my lord. Today I don't have, my lord. But,
You are on equal protection of law.
my lord, the second part, my lord, of the definition. My lord.
Nineteen 55 AR 55 Supreme Court 795 Sri Kishan Singh versus State of Rajasthan. TMA Pi Foundation versus State of Karnataka 2002 8 SCC 841. Government of AP versus Maharshi Publishers 2003 1 SCC 95. Amita versus Union of India 2005 13 SCC 721. State of UP versus Maqbul Ahmed 2006 7 SCC 7521. Soma Chakrabarti versus State 2007 5 SCC 403. These are the judgments on equal protection under law. What does it provide?
We'll find out, my lord, those judgments. We'll place it before election.
We can't go in a hearing in this manner. We start for half an hour. Then I'll read something and come. Tomorrow again, we'll start for a few minutes. I'll read that and
No,
come.
come full prepared, my lord.
You had enough time to prepare.
My
You should have,
I'll place all the judgments.
sorry. If the thought had ever come to you, equal protection of law, why didn't you explore what is equal protection of law?
My lord.
Then you could have been more ready with us.
I'll place it, my lord.
Sorry, we're not leaving you today. We would like to continue with the hearing.
I'll continue, my lord.
We'll provide your answers, you
My
were
lord,
saying.
regarding, my lord, the protection.
The answer is equal protection means the right to equal treatment in similar circumstance.
Yes.
Okay, so now proceed.
Regarding the first part, my lord. The,
So now you have to go to the first
No,
one.
my lord. I'm just, my lord, segregating the first part, my lord.
So equal protection is over.
No, my lord.
Then-
Segregating
no,
the first part
continue.
is, my lord, equality before the law.
Please make your further submission on equal protection now. What you want to submit?
Every individual of this country, my lord. My lord, if any proceeding is initiated against a man, my lord, suspecting his nationality, my lord. And if the person concerned, my lord,
No, we are not on the proceeding. Proceeding part is already over.
I'm going
That-
with it, ma'am.
We are on the consequence.
my lord.
Once that proceeding is over and a man is declared to be a foreigner, now what will happen with him?
If the
Don't-
same person, my lord, he claims to be an Indian citizen, my lord.
No, but he's already declared.
Yes, he.
So
but
that
somehow he
argument is
declared-
over. Stage of that argument is over. Therefore, we excluded Mr. Bhuya.
Right.
He wants to argue on his earlier part. Earlier part, we are not hearing. Or if you want, we'll hear you at the end of the hearing on your earlier part. Now we are on the question, if you are declared, what will happen? So don't go back to the stage that whether you are not a foreigner. We are not hearing on that part now. Once we conclude the hearing on this issue, if necessary, we'll hear you on that, but not now.
Regarding the my lord, equal protection of laws, my lord.
So you will, so the foreigner will also get equal protection of law according to you.
Not in every aspect. my lord.
Huh.
The my lord,
And
subject to the, my
equal
lord,
protection of law is, equal protection means the right to equal treatment in similar circumstance.
yes,
Meaning thereby, is the circumstance of a foreigner and the circumstance of a citizen are same? No. Come back again to square one. What are the laws applicable to the foreigner? You tell us.
a foreigner is
Instead
covered-
of going on these broad-based concepts, tell us what are the laws according to you, what are the rights you'll be entitled as a foreigner.
the foreigner is governed by the my lord, separate statute. my lord. Foreigners Act 1946 is there, my lord.
Mr. Ahmad, tell us in detail. That I'll have the right to buy milk every morning. Yes, we'll examine whether we have the right or not. Yes, I'll have the right to send my children to school. We'll examine whether we have that or not. I'll have the right to go and vote. We'll examine whether you have the right or not. Go on this way.
This people, my lord, who have been declared to be foreigners, my lord, they also, my lord, should be treated and should get some of the, my lord, treatment. Like, my lord, the
Mr. Hamad, that is where asking you, which are the treatments? Once you say, I am entitled to this, we'll examine whether you are entitled or you are not entitled. Then we'll elaborate and find out that these are the entitlements which a foreigner will have. And these are the entitlements which a foreigner will not have. That's all. Yes, anybody else would like to address on this issue? Anybody ready? Because we given a two judgment orders we have already passed that we welcome anybody.
Yes,
Mr. Ahmad, you prepare in detail and
my lord.
you are leading a good argument, but some in more detail. Yes, Mr. Hussain, what is your argument?
I will try to lordship. Lordship, so far as the fundamental rights are concerned, lordship, some fundamental rights are started with citizens. Those are exclusively for citizens, lordship.
Mr. Hussain,
Lordship.
don't go back to the basics. We all are aware.
Lordship. So far, lordship.
Come more in
de-
specifics.
Declared foreigners are entitled to get protection of 21A lordship. Like
Actually, a declared
life.
foreigner will be entitled to the protection under
21,
Article 20. And what is 21?
21 lordship.
Constitution. Bear it. Yeah, that's right.
Lordship.
No person shall be deprived of his life or personal liberty except according to the procedure established by law. So what you are entitled?
Lordship, he's entitled, declared person is also entitled to right to life, lordship.
Right to life
Life.
except according to procedure established by law. So respondents in exercise of the power under Section 3 of the Foreigners Act
Lordship.
deemed it appropriate to frame the Foreigners Order 1964. Therein clause 313, I think it's 313.
313.
They provide that you will be taken to internment and detention camps. So that is a procedure established by law.
Lordship.
So your right is to go to the detention center now.
Detention center, lordship. After that, lordship.
Under Article 21, the right of the foreigner would be to proceed to the internment and detention center now. Because that is the procedure established by law by them. And that order is not challenged by anyone. So this is the end of Article 21 then.
Lordship, so far.
We recognize Article 21, but under Article 21, your destination is the
Lordship,
detention camp.
Lordship, so far admitted foreigners, they are liable to be deported. In this case, those who are declared by the foreigners tribunal, Lordship,
So you want to distinguish between an admitted foreigner and a foreigner declared by foreigners tribunal.
tribunal.
What is the difference?
For example, Lordship, somebody entered into India with valid passport and visa, Lordship, visa expired or illegally
So if a man comes with a passport visa, overstays,
overstayed.
he'll be an admitted foreigner and he'll go to the detention camp. And if a man is declared to be an illegal migrant by the tribunal, as he did not come, as he initially also it's an illegal entry, subsequently also illegal, he'll not go to the detention camp. Are you trying to suggest that?
No, not like that, Lordship. He and
Other one at least entered legally, but
legally
illegally overstayed.
overstayed.
Here is a case he entered also illegally.
Till his deportation, he will be kept in detention.
So because of the double illegality,
No.
this man will get the privilege of not going to the detention camp.
No, Lordship, not
I
like
don't
that.
think it can be an argument.
Not like that, Lordship. Admitted one will be kept in detention center till his deportation
Yes, yes.
to his country of origin, Lordship. In this case.
And the
Lordship,
illegal migrant?
illegal migrant in this cases, so my little understanding is concern, Lordship. Country is not accepting that he or she is our citizen, Lordship. So they are having.
So you are trying to say that the deportation is frustrated. There will be no deportation.
Frustrated, Lordship.
So
And-
now, as there is no deportation, by implication, you are a citizen here. Are you trying to say that?
No, exactly.
No,
not
what
like-
are you trying to
But
say?
procedure can be, Lordship, that procedure can be, it is up to the government, central government, it is up to the central government, Lordship. They can.
Okay,
adopt the
central
procedure.
government will ask him. So therefore, we have Mr. Chaudhary before us.
Lordship, it is up to the central government.
We'll ask Mr. Mojumdar also what the state wants to do.
Yeah,
also.
yes.
That is
And
a
so-
different aspect.
Yeah, and so far
But
opinion.
we are just trying to know from you.
Lordship.
What
So far opinion is concerned, after giving opinion by the foreigners tribunal, it is up to the central government to act upon that opinion. Whether they will accept.
So you mean to say it is up to them to act upon it? If they don't act, I'm a citizen.
They may allow me to apply for citizenship. It is up to the central government.
Understand.
Discretionary power,
So
Lordship.
now it is discretion of the central government. They may allow you to become a citizen.
Or. Lordship.
Mr. Chaudhary, you want to allow them to become citizens? So that's the end of it.
Or
Now?
they, it is up to them to deport me,
Deport you yourself say your country of origin is not accepting you.
accepting
It
or,
cannot be deportation.
or it cannot be ascertained like.
So now what will happen to these people?
Fatal-
They can't be sent to heaven.
No, Lordship. No, Lordship.
What will happen with them now? We were precisely trying to explore this issue.
And so far detention period is concerned, it is now confined to 2 years only. After coming out from
After
detention,
coming out, what will happen to you?
For
You'll become a
years.
citizen.
they may get married or then extension will be there.
So you'll be, so after coming out, you'll get married.
Lordship.
And after, and once you get married, you are a citizen.
No, Lordship, I'm not suggesting like that.
Please
Miss
tell us in a
Lordship,
more
the
concrete manner.
It is up to the central government to adopt a procedure. If I'm here for more than 7 years or 15 years like that, Lordship.
Central government has not done it
No,
because there was a requirement of the Supreme Court in 2015, paragraph 46.2 of the judgment in Sarvanwal Sonwal second, I think. For 8 years they have gone by, they have not done anything. So you can't throw it on that. So we are asking you, what kind of rights you are claiming? Once you are a declared foreigner, as long as you remain in this country, what kind of rights you are claiming? We are asking you that question. If you say, I claim X right, we'll examine it as per the constitution, as per the law. If you are entitled, we'll declare you. that yes, you are entitled to that right. But it must be for coming from your side.
Or there was some research you require.
We have given you, this hearing started 15 days back. We have been giving you enough of time to do your research. Research doesn't mean it's a perennial proceeding. What is research? Research is a self-taught. That first I think in this line, these are the possibilities, these are the obstacles. This is where I am required to go more in detail. You go in detail. After going into detail, you again find that these are the possibilities. Here I am required to go further detail. You have to do it. Just raising a headline is not sufficient. Then who will do the rest of the work? Court. Yes, I have raised the headline of my argument. Now you pass your judgment, whatever you want to pass. Do all the research work, do everything. Let the court do it itself and pass your order. Are you suggesting that? Yes. We know research is required, therefore we give you adequate time. We did not begin the hearing all of a sudden. Okay, you prepare yourself. Otherwise, you'll start hearing the respondents now. Because we had given you the opportunity, enough of opportunity. It's the second or third day of the hearing today. Mr. Awan, you appear to be quite excited. You have something in your mind. Every time some question is put, you are trying to spring up a little from your chair.
My lord.
Want to say something?
No, my lord, just on this issue on convicted, as my learned friend has said, on convicted foreigners and declared foreigners. This distinction, we are not making it. The government is making this distinction, that there is a set of convicted foreigners who are convicted by the
We'll ask him. That we'll ask him.
criminal courts, and there are certain foreigners who are called declared foreigners. Those are declared by the foreigners tribunal. Now, as my learned friend is saying that they cannot be deported, the government of Assam before the Honorable Supreme Court has stated that only 4 declared foreigners have been deported till now. And the convicted foreigner is 162. So the distinction is made by the government itself.
So where does it lead us?
My lord.
It does not lead us anywhere.
So my lord, my humble submission would be that if a person, a declared foreigner, is detained, he is detained for the purpose of deportation. Now, that person cannot be deported, my lord. In the last 4 years, almost 30 people have died in detention center, and their body has been.
We are not on your political statements.
No, my lord, I'm just actually.
We are, Mr. Aman, we made it very clear in the very first day. We made it clear to Mr. HRH already.
My lord.
Don't project your political agendas here. What is to be done, what not to be done. We are precisely on what legal rights you have and what rights you don't have. That's all. Confined to that.
One of the rights.
Who died, who not died, how many figures, we are not interested in all
Coming to
those.
that.
Figures may be in lakhs, figures may be in 1,000, figures may be in tens also. That doesn't matter. Even if it is one also. What legal right will that one have and what legal right that one person will not have? So your facts and figures doesn't make any difference for the court proceeding.
So my lord, my humble submission would be one of the
And
rights.
how many died, that also doesn't matter. It's a question of the human rights authorities to take up. Here the issue is what you are entitled and what you are not entitled. Confined to that. If you have answer, please submit. If you don't, you may not.
So my humble submission is that one of my right would be right not to be detained, my lord. Right?
Understand, your right will not to be detained, but beyond that, what will be entitled?
My lord, as my earlier learned friends have.
So after you are released, you'll be entitled to all the rights and privileges of a citizen.
My lord, Article 14, which says equality before the law, it means that equals need to be treated equally. Unequals should not be treated equally.
So you mean to say a foreigner and a citizen are equal?
I'm not saying that.
Then-
I'm not saying that. But
Then
also,
14 is not applicable.
my lord, 14 is applicable for the simple reason, my lord, that it should be read with Article 21, which says that right to life means right to life.
Mr. We are not on these broad-based arguments. We want a specific argument. That this I am entitled. Moment you say I'm entitled to this, we'll examine whether you are entitled or not.
My lord, I'm coming to that.
Please
So-
come straight away.
So Article 21, there are some range of rights that the Honorable Supreme Court has decided in.
And
many-
Mr. Awan, we are telling you, everybody present here are aware of the constitutional provisions.
My lord, my
The
lord,
reiteration is not required.
my lord.
Make your argument minus the reiterations.
Recently, my lord, the.
Suppose
Honorable-
I accept your argument and declare, yes, the foreigners are entitled to the protection under Article 21. I don't write anything beyond that. What will you do with that judgment? You're back to square one.
My lord.
So go a little ahead of that.
My lord, my humble submission is that even if a person is a foreigner, that person is entitled to right to live with dignity, which includes, my lord, a right to food, a right to health,
Okay,
right
now
to
you're coming.
education,
Right to food.
right to food, my lord.
Why everybody took almost 45 minutes to come to the terms? This is what we are trying to understand from you, what you are entitled, what you're not entitled. You are Awan.
AW Aman.
Entitled to
One,
number one, right to food.
right to food,
Now, right to food means, suppose the foreigner is here, he has nothing to eat. So the state has to go to him and provide the breakfast, lunch, dinner every day.
no, my lord.
Do you mean to say right to food means that? Or right to food means something,
My lord, the government,
something more in detail?
the government has the PDS system, my lord. They,
PDSA, so the NFSA.
yes, my lord, they
So
provide,
NFSA account some.
they provide ration card so that the poor. people-
Understand. Let us look at the NFSA Act.
My lord.
So you have the act with you.
I don't have the act with me.
Then why you raising a submission without bringing the act? Mr. Awan, we told you we don't want this broad-based, we want specific arguments. Because we are seriously trying to
My lord,
examine the issue
I bow before your
and we don't want any dilution of the process. Nor we want any agendas to be encouraged.
not at all. my lord.
Your agendas you carry elsewhere, wherever you are required to do, not here. Here, we are making a very serious attempt to find out what this category of people will be entitled and what they will be not entitled. And neither we want the submissions on the figments of your imagination. We want your submissions on the base of thorough research on the subject.
My lord, I will assist your lordship. I need 1 day time.
Yes, you can do that.
My lord.
Mr. Chaudhary, RKD Chaudhary. I think you'll have to come in to some extent.
Yes.
Suppose we accept his argument, right to food. Right to food definitely can't be that these people will come. They'll be staying somewhere. The government every day will go out with breakfast, lunch and dinner and they are not hungry. Possibly the system may not be that. Mr. Awan raises that he expressed a ration, food ration,
My lord, ration card.
food ration. Now this is basically covered by National Food Security Act nowadays. I think
That would be applicable only to the citizens.
this is what we are trying to learn from you. So these are National Food Security Act is applicable to eligible households. Okay. Eligible households covered under the priority household and Antodaya Anna Yojana. What is this Antodaya Anna Yojana? Can you?
Worship, some quantified dry ration is given to.
Something is there. Priority household and Antodaya. Priority household means household identified under section 10.
It will be done by the district
Hmm.
authorities.
Section 10 is shall within the number of persons determined under section 9 of the rural and urban identify the households to be covered under the Antodaya Anna Yojana. Again, the same Antodaya Yojana comes in to the extent specified under subsection 1 of 3. Remaining household as priority households to be covered under the targeted public distribution system, provided the state government may, as soon as whatever audience has not extend 3 years after commencement of the act, identify eligible households in accordance with the guidelines framed under this section. Any guidelines, Mr. Nath? Guidelines are there. I think you have to bring those. We have to examine the claim for right to food, to what extent you are entitled, what you are not. Provided further this, they shall continue to receive allocation of the state government. Nothing beyond is provided. So you have to go by Antodaya, that Anna Yojana and targeted public distribution, then your guidelines.
Perhaps, Lordship, they would not be covered by that.
Sorry,
They would not be covered by that.
foreigner. Yeah, this is what we want to examine. If it is not,
It-
you have to put
Yes.
it across to Mr. Awan, then you have to hearing what he has to submit on that.
Because they are not eligible for the ration cards. This will, one is for the BPL and another is for the above.
One
BPL.
thing, foreigners law concern.
Yeah.
What will happen to this category of people? You can refer to section 3 of the Foreigners Act.
Like go to the-
Power to make orders.
এটা আপনি এখন গণ্ডগোল হয়েছে। আপনার This one is-
The central government may, by order, make provision either generally or with respect to all foreigners. Generally or all foreigners, both categories, okay? Or with respect to any particular foreigner or any prescribed class or description of foreigner. Everything is permissible. Foreigners can also be classified into different kinds of foreigners. So the law permits it. For prohibiting, regulating, or restricting the entry of foreigners into India or their departure therefrom, or their presence or continued presence. Here, we are basically concerned with presence and continued presence. Departure is another subject. It will be dealt with separately by the central government. Whatever happens, the outcome will follow. So, in particular and without prejudice to the generality of the foregoing powers, orders made under this section may provide that a foreigner shall not enter India or shall enter India only at such time as by such route as port or said. So this is not applicable for, at least timing for our purpose. We shall not depart from India or depart only at such time. This is also not applicable for the time being. Shall not remain in India or in any prescribed area therein. So this is, you decide as per that paragraph 46(2) of that judgment of the Supreme Court. Shall, if he has been required by order under this, say not to remain in India, meet from any resource at his disposal the cost of his removal and of his maintenance. This one throws some light. See. Shall, if he has been required by the order under this section not to remain in India. So once you are declared foreigner, by implication, you are required not to remain in India. But you remain. Meet from any sources at his disposal the cost of his removal or maintenance therein pending disposal. So we take this one to be the relevant. Of his maintenance therein, how he will maintain therein. So I think this can be read in the context of right to food also. How it will be done? Meet from any resources at his disposal. Okay. So you have to make your order. This is a order making power. You'll have to make some order. That how he will maintain his presence. It can be to meet from any sources at his disposal. So now,
310.
Mr. Chaudhary, if he is required to maintain himself from the resource at his disposal, then you will also have to facilitate the person to acquire his resources also.
That is,
If you keep him in a detention center, he will not acquire any resources. State will have to feed him. Definitely, if you are detaining, you are bound to feed. You are feeding other prisoners also in the jail. Why you have feed the prisoners? Because you are curtailing their right and entitlement to create their own resources. So you feed them. So this is one vital aspect, please take note of.
this, so far as what has fallen from your lordship,
No, nothing has fallen for us. We are only
it's just a matter of. lordship.
showing some directions here and there because almost everybody is little directionless. Let us give some more direction.
A particular case of lordship, Professor Bhim Singh versus Union of India. That is the 2012, 13 SCC 469,
Him Singh,
him saying.
Panthers Party. Him Singh is Panthers Party, he's a famous person.
Maybe Panthers.
So,
Now, here in Lordship, the Honorable Supreme Court has observed.
shall we take out our printout?
Yes.
Border लगाई दियो हमारे इंडिया को नहीं सुना
13 SCC 469.
We will come back. 5 minutes. Most of the answers may be in section 3. Just look into it. Specified requiring him to reside in a particular place, imposing any restriction on his movements. So this is statutorily permissible. But that does not mean, and in response thereof, we have framed the Tribunal's Order 1964, where in 313 is provided where the proceedee fails to produce any proof in support of his or her claim that he or she is not a foreigner, also not able to arrange for bail, the proceedee shall be detained and kept in internment or detention. This is all that is provided. But under section 3, it's a wide-ranging power is vested on the central government. (313) maybe you can say pursuant to 32E, requiring him to reside in a particular area. But putting in a detention and residing in a particular area may not be one and the same. And that too, we can take judicial notice. Sometime back, I was handling with a petition where most of these detention camps are a part of a jail. Now it is changed, of course. There are some orders were passed on that. Sorry, a little louder. It's not coming.
I was looking at that order, Lordship. I was a part of that procedure.
You are part of that. No, we are not. We are not going into these aspects. So we are just pointing out the extreme forms that this can take place.
Lordship.
But requiring him to reside in a particular place may not be looked into from such extreme point of view. Imposing restriction on his movements, he can impose some restriction in some vital places that you can't go into these places. But that doesn't mean he'll be confined and detained. So when you read C, C, and E, some kind of a direction is available, which may meet some of the submissions of Mr. Awan, although it may not be that broad-based. And Mr. Awan, you also look into a little deeper. make it something reasonable, acceptable under the law. Neither it must be too far-fetched, nor it must be such from the state's point of view that it violates all other different kind of laws. Make a balance between the two. If it is acceptable, we'll issue directions on that. Don't try to take something you are not entitled. And don't try to also not have what you are entitled. In the morning, I referred to one song by John Lennon. Okay. In this context, there is another famous song, a country song in America. Precisely on this one. One particular line is very relevant of that song. It's a traditional country song which was written when the local American population was totally overwhelmed by the invaders. You find out which song, and the one particular line is there which is very relevant with this one. The line is, take what you need, but leave the rest, but don't take away the very best. So, balance yourself. We continue tomorrow? Well, I think this will need some preparations, at least. Sorry.
We can continue, but then now that many things have come up, if your lordship takes it up on Monday, possibly we'll be in a better position to place the relevant
So we'll
materials.
do it tomorrow or also on Monday. Tomorrow is 3 o'clock, second half. We'll have a continuous hearing every day at 3 o'clock for a few days.
So the other matters can be taken.
Ah. And Lordship is indicating whatever you want to submit, you formulate the points, detailed points, not just the broad headlines. Give it to us also, so that we also start looking from that point of view. And also, and from Mr. Chaudhary and Mr. Majumdar, we'd also like to know what they are not entitled. That
Yes.
also has to be specifically provided. And we don't compel Mr. Awan to say what is not entitled, so at least you say, he will examine.
He will try to say he is entitled to everything. We'll try to carve out an exception.
Yes, Mr. Chaudhary.
It was.
No, it's okay.
Problem is there.
It's okay. We have some directions we have arrived at. We can, Mr. Awan can brief you. No, his party is over today. He can brief you, and you also make your submissions.
My question was. Then tomorrow,
We want to just on the limited issue, what they are entitled, what they are not entitled. That's
those
all.
were declared.
Yes. Not on the implication, what ought to be, what not ought to be, what should be the state policy. This is entirely for the state. We are not going to all those issues. Within the existing legal framework, what they are entitled, what they are not entitled. That's our, we don't go anything beyond that.
Just one Primarily, my lord, after a person has been declared foreigner, he is to be deported.
Here comes up. So,
Where he is to deport, whole problem comes here. Sub spending council,
One case.
all spending council.
My lord, may I kindly see this section 3 of the Code.
We'll go to this section later on.
My lord.
It was, I think. It was 1 minute.
The section code of. Section 3.
Yes, Mr. Mojumdar,
My lord,
the Supreme Court in 2015 3 SCC,
yes, yes.
paragraph 46.3.
No, I'm having this. Yes.
While taking note of the existing mechanism procedure for deportation, keeping in view of the requirements of international protocol,
Yes.
we direct the Union of India to enter into necessary discussion with the government of Bangladesh to streamline the procedure of deportation. The result of the said exercise be laid before the court on the next day.
And they're late also. Why, they filed an affidavit.
And what was the
They filed
outcome?
an affidavit.
What was the outcome? What was stated in that affidavit?
I'll take a printout and before the court tomorrow.
So for deportation, that is what Supreme Court is dealing with.
Yes.
We don't venture into that.
No, no,
question.
no. What I was saying is, my lord, till he is deported, what rights he will have? that is the
Basically on
case.
that, yes.
Because certain rights like food cannot be provided for entire life of this person.
This is what food, definitely
Food-
something is there.
Till the time he is deported.
Ah.
And Article 921 till the time he is deported.
But if the till,
Cannot.
but if the till does not come,
It has to come.
and if the till goes to the next generation,
That is what marriage, it cannot go.
then it
Not
goes to
coming.
the further generation.
No, it
Then
cannot.
what will happen?
No, it cannot go.
Till will not come, my lord. Till is not coming, it will never come.
But so we are not on hypothetical situation. We are on the real situation, not the virtual situation.
Yes.
Even if it is for 5 days also, what he'll entitled, what he'll not entitled.
Yes.
Just that one
That
till
much.
may happen in future.
Yes.
We are putting it in a deviated manner. We are not looking from that point of view. If you are
As a-
here for
As a declared for.
5 days, these are your entitlement, you are not in your entitlement.
This is what.
If the circumstances, you are here for 30 years after that, still this will be the entitlement, not entitlement.
Yes,
If you are here for generations also, this will be the entitlement.
No, section, my lord, my lord, is referring, it does not say about deportation. It shall be arrested and detained or confined.
no, it says.
This is
Three-
by amendment is well.
No, 3 to C.
No, 1G. So. They have G, by amendment,
3 is they can make order, central government,
yes,
providing for they shall not remain in India or in any prescribed area there.
that's what.
Does not,
but
word deportation may not be used, but you will not remain.
Yes.
but
So, Mr. Chaudhary, if deportation is taken out and if does not remains, what will be the implication?
so many implications will come in that case. Political implications, social.
No, forget, we are not on those.
So many implications will come.
No, think broadly. Law provides shall not remain in India. So within this territory of India will not remain. You say deportation not possible. Then what is the third option? If both has to be complied. There is no deportation, there is no remaining, then
Stateless.
that's a,
That also your lordship indication.
And that is not an acceptable way. So we have to find something different which is acceptable in law. Otherwise, crude meaning given to both the expressions is that only. So let us not go into all this. Let us make a sincere attempt to find out.
Tomorrow, 3 o'clock.
Hmm.
Tomorrow at 3 o'clock.
Tomorrow we'll have a day-to-day hearing.
Who is the Monday?
Where's your lordship? No, somebody they are saying Monday, it is up to your lordship, but because.
No, tomorrow. Day-to-day. Monday will also be accommodated. We'll have it on Monday also.
Yes.
If some learned council is comfortable on Monday, he can address us on Monday. But
We'll continue.
we'll continue tomorrow. Heard in part. Hearing remains inconclusive. List for further hearing on tomorrow to be taken up at 3 p.m.
Mr. BC Das is also here. I requested him the other day.
Now. he is also
Mr.
coming.
Das was already here before.
Yes, that is why, because I was not there, so I
There he is,
requested him on behalf of lordship.
right behind you.
Meeting is being live stream.
Oh.
আমাদের চেহারা সেলিব্রিটি
Oh, right.
আমরা সেলিব্রিটি
And Mr. Chaudhary, if you, as we are discussing, that E again contains number of further subclauses that Foreigners Act, Section 3. One is requiring him to reside, 2 imposing restriction, 3 is requiring him to furnish such proof of his identity report particular to such authority.
Section 3.
4 requiring him to allow his photograph, fingerprint impressions be taken for his specimen. So that means their presence must be regulated.
Yes, yes.
Some authority must be having the knowledge of their presence. The records will be maintained. Even the movements, etc., will have to be regulated. Requiring him to submit a medical examination, that is okay. Prohibiting him from association with persons of a prescribed or specified description, this is relevant. I think you'll have to frame a more detailed order, it appears. Over and about the 48, possibly there is a requirement of framing a more detailed order. Then prohibiting him from engaging in activities of prescribed or specified, this is also very relevant. What you can do, what you cannot do. Prohibiting him from using or possessing prescribed or specified articles. This up to you. Otherwise regulating his conduct in any such manner as may be prescribed or specified. So I think we'll at one time, maybe we'll require an affidavit from you on this.
Possibly.
What precisely you want to provide and what precisely you do not want to provide. Not do not want to, do not provide, it's already will determine, provide also will determine. After providing how you are going to regulate the affairs, maybe for that purpose. Until such order is framed, we'll make a part of that affidavit to be a part of the judicial order.
Yes.
You file your affidavit, we'll have a deliberation and discussion on that. We'll hear the others also.
That one in the light of 2015 3, my lord, paragraph 46.3 3, my lord, that is. That your lordship, yesterday your lordship. also
46.3 is deportation.
Yes, so that, my lord, what exactly your lordship.
Deportation, we don't know.
No, I don't know how that dealt with, but central government was requested with us.
No, we don't, because the Supreme Court is in session of that.
No, we direct the Union
we-
government to enter into
uh,
necessary,
We don't want to venture into that question.
but what happened to that, my lord, that is what. We should know it, my lord, because what happened?
You make an application under RTI, they
No,
provide.
but they are, because they are the person who can say. better.
Mr. Chaudhary, you make an application under RTI, they'll inform you. A court proceeding cannot be made to obtain information from the other side.
No, my lord, this is a court proceedings, that is Supreme Court, my lord.
You find out.
Your lordship, other day asked the to say.
We
that-
are very clear of the contours within which we are going to operate. This we find it little beyond our control. Because the matter is in session of the Supreme Court, let the Supreme Court deal with it. Where the Supreme Court is not dealing, only the vacant space we are trying to put in. And till the Supreme Court decides this issue, what will happen to this category of people? We are only on that. And that period of what will happen, maybe, as I said, maybe of a few days, maybe of a few years, maybe of a few decades. Or maybe of a few generations also, we don't know. But we come into that.
Tomorrow, man.
Obliged.
If you want help of anybody, you can take somebody's help also, if you want. Mr. Nath, should you take up that? Oh, it's not here today, no? Section 97, is it here today? The para 97?
Tomorrow.
Tomorrow, not today.
Not
That's
today.
right.
Item 3,
May I please, your lordships?
Yes, please start.
Yes, lordships. Page 33 is the Bhutan list of 1965. My grandfather and father.
Page
Page
33.
33. Petitioner's name is Nureja Begum. Here is my grandfather's name and my father's name. Grandfather's name, serial number 688.
Who is the grandfather? Dilnur.
Dilnur Ali and my
He is
father.
the grandfather.
Lordship.
And who is the father?
Noor Haq. is Noor
Page
Haq.
number?
Bottom lordship 691.
But the same word.
Lordship,
Nur Haq is the father.
father. Then page 35 lordship also. Only my father's name. Because certificate can be obtained only in regard to my father, that same house. Father's name. Noor
Bring
Haq.
the complete voters list.
Yeah, but lordship, then next voter list, lordship, page 37 lordship.
Who is Nur Haq? The
Noor
petitioner
Haq
is
is
Nur
my
Haq.
father. My name is with
Okay.
my father, page 37.
Very well. Nur Haq is the father. Now, where is the petitioner?
Petitioner, lordship, page 37, bottom, Nureja Begum,
Nuresh Begum.
lordships. Actually,
Nuresh
Nureja
Begum
Begum
is the petitioner.
wrongly appeared Nuresh lordships. And then again find page 39 also, correctly appeared Nureja Begum, page 39.
Manipur PS Rohara. Pooja Hipukuri. Where is the notice?
Notice lordship is page 47 with my husband's name, page 47.
Acha, notice contains husband's name.
Lordship, address husband, married,
Not so.
married 1994.
Father's name is not there.
My
How do you know that a petitioner Nuresh Begum
lordship,
and that page 37 Nuresh Begum, they are the same person?
my evidence is very much clear, lordship.
Whose evidence?
I gave. my
That is your own
evidence,
statement.
But certificate, lordships,
Which
matriculation certificate,
Page number
page number 21.
21. But this village is different. Village is Jajoni.
But
Other
post-
one is
post office
Bormonipur.
Bormonipur. Big area, lordship, that's right. Post office shows Bormonipur.
Hmm.
Post office Bormonipur. Area
Post
is a
office.
big area, lordship, Jajori. Post
So
office
Jajori and
Bormonipur,
Bormonipur, they are same place.
same area, lordship.
Yes, Mr. Paing, is it the same place?
I cannot say because it is not possible on my part that it is same place. But my lord, I'm surprised if it is his.
So you make a verification.
If it, my lord, if it is the petitioner, my lord, because petitioner, as per claim, my lord, petitioner was in Bormonipur up to age of 18 years. And this certificate, my lord, the school certificate cannot be the village of, in the village of Jajori, because Jajori is her, my lord, married village. School certificate cannot contain the name of my lord married village. If it is given
Achha,
on the basis of
Jajori is the marital place.
married place.
Yes, Mr. Bormaya, you did not say so.
Jajori, lordships,
Because the notice
Jajori,
contains
that is
Jajori
Bogriguri. Marriage place, Jajori, Bogriguri, sir. So,
Hmm.
Bogriguri. Jajori, Bogriguri.
And he,
21.
the voter list relying by the that
His certificate.
her name was there is Bormonipur. So her, in the certificate, it should be Bormonipur because I don't think, my lord, the person who was reading at the age of, my lord, in the class 10, he should be above 18 years.
Sorry.
No, my lord, the Jajori is the present village when the petitioner notice has been served, my lord. So certificate saying that she was reading in the school, my lord, it should be before the age of 18 years. So it cannot be in the Jajori
Mr.
village.
Paing, is there not a conception called exception?
No, I am not saying, my lord. The thing is that, my lord,
In society, is the concept of exception not available?
exception, my lord, it can be, my lord.
Mr. Paing, if I accept your argument that in a school beyond 18, no one will be reading,
No, he was,
then matriculation also before 16, no one will be giving.
no,
Fif-
he was,
fif-
my lord, he was reading in the school
So-
in 1992 as per the certificate itself.
Mr. Paing, we understand what you are saying. So that means before age of 15 or 16, no one is there is matriculates also.
My lord.
So if I tell you the name of a particular specific person and borrow your concept, that person has to be removed from the office the person is holding
My lord, my
straight away
submission,
because the matriculation was at the age of about 15 or so.
about 50.
So if you go by exceptions are always there.
Exceptions are always there, my lord.
So then
But-
these,
But my lord, certificate itself says she was reading in that school in 1992.
Higher secondary.
Higher
yeah,
secondary.
you're not interested.
And in fact, my lord, in 1997, the voter list which she is relying, my lord,
1989.
1989, her village was, my lord, Bormonipur. So the village name should have been Bormonipur. That is my submission, my lord. This Jajori is the present place. My lord, the record of the school should contain this, my lord,
Okay.
Bormonipur village. That is-
Heard Mr. F.U. Burmahir and counsel for the.
One, my learned friend said Jajori is a big place. Jajori, Bogriguri, and
Very
Jajori, Bormonipur.
Very well. Mr. The petitioner Nureja Begum had been referred to the Foreigners Tribunal number 1 Nagaon for rendering an opinion as to whether she is a person who entered the state of Assam from the specified territory subsequent on or after 25/3/1971, resulting in registration of FT case number 59/2018 an opinion dated opinion dated so had been rendered by which the petitioner is declared to be foreigner, being aggrieved, this writ petition is instituted. The petitioner refers to the relies on the voters list of 1965 of village Bormonipur, PS Roha, Moja Silpokhuri in the Nagaon district, which contains the name of Dilnur Ali, son of Baneshwar at serial 688, and that of Nur Haq, son of Dilnur at serial 691, and both of them are indicated to be residing in the same house number 160. Petitioner also relies on the voters list of 1970 of village Bormonipur, wherein at serial number 613 is the name of Nur Haq, son of Dilnur. Petitioner thereupon relies upon the voters list of 1989 of village Bormonipur, police station Mikirveta Moja Silpokhuri in the Nagaon district, which contains the name of Nurul Haq, son of Dilnur at serial 105, and that of Nurez Begum, daughter of Nurul Haq at serial 107. And both of them are shown to be residing to be resident of house number 32. The petitioner also relies on a certificate issued by the principal of Jojori Higher Secondary School, Nagaon, which contains the information that Nuriza Begum is the daughter of is an inhabitant of village Jajori, post office Bormonipur, under police station Mikirveta. As well as a certificate issued by the principal of Jojori Higher Secondary School, Agorkhan dated 49/8/1989, Agor certificate, this one dated 2012-2016, wherein the information contains that Nuriza Begum is the daughter of Nurul Haq, who is an inhabitant of village Jojori in the Nagaon district. As the voters list relied upon is of village Bormonipur and the school certificate is of village Jojori, indicating the residence of the father of Nuriza Begum, comma, Mr. F.U. Borbuhia, Learned Counsel for the petitioner, raises an explanation that the village Bormonipur is a big area and Jojori is a part of the.
Jojori is a big area.
Jojori is a big area and village Bormonipur is a part of the village Jojori itself. Is an area within the village Jojori itself. Mr. J. Paing, Land Counsel for the Home Department of the Government of Assam, has raised an issue that the certificate dated 14/9/1989 shows the date of birth of the petitioner to be 1/1/1973, and therefore she could not have appeared in the Assam higher secondary examination conducted by the Assam Higher Secondary Education Board in the year 1992, as she would have been more than 18 years of age at that relevant point of time. Mr. Pine has based his argument on a presumption that a person beyond normally a person beyond the age of 18 years do not continue any further to read in a school. Is it so, Mr. Pine?
My lord, that is not my contention, my lord.
What is your, please repeat, we are writing.
My contention is that, my lord, if she was a resident of, my lord, Jajori village in 1992, she cannot get married because she's, as per my lord record, it is said that she was in Bormonipur as per the voter list in 1989, my lord. So, but the school certificate says
Mr.
that she's a
Payeng,
resident of
although
Jajori.
initially raised the objection, subsequently on being questioned, withdraws it and makes a further submission that if the petitioner name appeared in the voters list of village Bormonipur in the year 1989, she could not have been reading in a school at Jajori in the same year.
But my lord, the school certificate contains name of the village is Jajori.
Voice recorder to on kori goteke report kori diok so. Every time you are changing, put the voice recorder on and whatever it is, yes, make all the submissions.
But the only thing is that, my lord, the petitioner in 1989,
Yeah, jitu koi ase likhi thako sir.
1989 my lord, voter list, she is showing that she is a resident of Bormonipur.
Likhi ase.
My lord, and but my lord, the school certificate of 1989, the residence of the petitioner is showed as Jajori.
State submitted that quote kori dibo ha. Yes, please submit.
So
Yeah,
both
record.
cannot be correct, my lord. Either he should be resident of Bormonipur or she should be resident of Jajori. Because in the same year, both the names are in.
Enough. Yes, it exactly quote kori dibo. This is the submission. The aforequoted submission raised by Mr. Payeng makes it discernible that the objection is raised that if the petitioner was name appeared in the voters list of village Bormonipur, she could not have been reading in a school at Jajori. In other words, there is a presumption by the state respondent that Bormonipur and Jajori are two different places located separately. But a contention has already been raised, but an explanation had already been rendered by Mr. F.U. Bormohia, Land Counsel for the petitioner, that Jajori is a bigger area and Bormonipur is an area within Jajori. Neither the submission of the learned state council nor the explanation by Mr. F.U. Bormohia can be verified by the court in a writ proceeding. But fundamentally, as the petitioner has raised a claim that she is Nuriz Begum, daughter of Nurul Haq, whose name appears in the voters list of 1969, and the name of Nurul Haq, Nur Haq, father of Dilnur Ali, appears in the voters list of 1965 and 1970, which would indicate that Nurul Haq himself is a citizen and the petitioner may be his daughter. Prima facie link may have been established by the petitioner that she is a citizen. Therefore, said issue requires further examination. Accordingly, matter remanded back to the tribunal to examine as to whether the voters list of 1965, 1970, and 1989 in respect of village Bormonipur indicates that the petitioner is a citizen of India. In doing so, the two school certificates, data 4989 and so we also examine. The petitioner may examine the principal of the school to be present before the tribunal along with the school records to corroborate the information corroborate the information contained in the two school certificates regarding Nuriza Begum and her name of her father. Regarding the objection raised by Mr. J. Payeng that Bormonipur and Jajori may be two different places, the respondents in the Home Department through the Superintendent of Police shall verify the factual aspect and submit a report and material before the court as to whether it indicates the same place or they are two separate and distinct places away from each other. Based on the material, the reason order will be passed, the same thing.
Petitioner Lordship Nureja Begum, Bhutan list showed Nureja, next one Nureja shows, actually Nureja.
We go and explain it like that. We are only private facie can be indicated, so we are sending it back. Money, money,
Hearing matters.
Hearing. Item 4 is appearing.
Item 4.
4 is. Item 4 you are appearing. Are you ready?
I am appearing.
Are you ready with the hearing?
Yes, my lord. Yes, simple prayer, my lord. Petitioner's elder sister already remained back, my lord, by this other court 2 months.
The simple question put back.
Yes, my lord.
How do you
established
know
linkage,
that
my
the
lord.
other person
My
is
lord,
the elder?
established linkage, my lord, birth certificate, school certificate.
Mr. Motin, we are not a NRC authority sitting here, or the linkage and legacy data and all. We are not on that.
Yes.
You say the elder sister, we ask you, how do you know that that person is the elder sister?
Yes, my lord.
You
Yes.
establish it.
In this case, father adduced evidence, my lord, as DW 2 months.
You better go by the core requirements. Discharge your burden under section 9. Do it. Instead of adopting this
Yeah.
deviated method, you establish your link. Establish your citizenship.
Yes, my lord. In this case, my lord,
Hmm.
a petitioner grandfather name appear in the voter list of 1966.
66 of which village?
Dev Dhuturi.
Sorry,
Dev Dhuturi.
Dev Kuturi.
Dev Dhuturi.
Okay, and father?
And my lord, thereafter, my lord, petitioner's grandmother appear is voter list of 1966 also, my lord. Dev Dhuturi village.
It's
And
okay. Now,
petitioner's
father, where does he appear?
Yes, father name also appear in the voter list of 1985, along with the grandmother, my lord, Dev Dhuturi.
Same village along
Same
with the
village, same
grandmother.
village,
Grandmother and grandfather together in
Yes, yes, the grandmother and
1965 and in 1985,
85.
father and grandmother together.
Yes,
Same village.
same village.
And now
And my lord-
with the petitioner,
And petitioner, my lord, a birth certificate, my lord, page 33.
what does it
Dev
provide?
Dhuturi, my lord.
Dev Kuturi,
Dev
sir.
Dhuturi. And
Yes.
school certificate also produced by lord in the tribunal, my lord, in the LCR page 30.
Yes, Mr. Pine, you look into it. We'll come back at 2 o'clock. If what Mr. Motin says is right, 65 grandfather and grandmother together. Same village, 85 father and grandmother together,
Yes.
and supported by a birth certificate. Maybe he had recharged the burden.
Why not say, the birth certificate is obtained only in 2015 then.
Doesn't matter.
There is a.
Mr. Pine, we are going to reject some of the frivolous objections being raised. Birth certificate law is already determined by the court. It's issued under a statutory provision. It has its own evidentiary value. Read the judgment. And as per the judgment, whether this objection is tenable or not, you take your own call.
Issuing authority examine.
Sorry,
Issuing authority examine, my lord, birth certificate.
you read the judgment and make the
Yes, my lord.
submission.
And my lord, it is a delayed birth certificate after obtaining the
Yes.
permission from the deputy commissioner.
Mr. Motin,
Yes.
why are you diluting your own position?
Yes.
Read the judgment on birth certificate and then make your submission. The entire evidentiary value of the birth certificate had been discussed in detail in one of the judgments. Read it. Don't know. Get the information from the court master. He'll tell you. Mr. Motin and Mr. Paying, if a birth certificate has to be proved, then tomorrow, when you apply for a job, when you apply for admission in a higher institute, you'll have to take the person issuing the birth certificate to render evidence before them. Are you required? Hmm. Are you required to bring evidence on birth certificate? Suppose you go for a job where you rely on the birth certificate because your age is material in some jobs. Do you take the person issuing the birth certificate to render evidence? Or you only submit a certificate?
No, my lord. That certificate has to prove, my lord.
Huh?
Has to prove the birth certificate, my lord, by
Has to
issuing the calling authority.
Yes. Then
Contents of the certificate may be proved.
we dismiss your case.
No, my lord, this certificate is proved by the issuing authority, my lord.
No, then we dismiss your case. Your case is based on birth certificate. Birth certificate has to be
And
proved.
not only birth certificate, my lord, school certificate also, my lord. School certificate also proves happening. And not only birth certificate. my lord.
You confer with Madam D. Ghosh.
Yes,
Come back.
yes,
And then make your submission whether birth certificates have to be proved or not.
yes. Public document, my lord? Huh? Not required to be- with the public document, my lord,
Item 4.
Yes, now whose name I write? Your name or Mr. Payne's name?
Lordship, due to some health problem, Lordship.
No, no,
he left the court.
we are not on his leaving. Whose name I record in the order?
Yes, Lordship, as your Lordship, this Lordship,
Sorry,
as your Lordship, please.
we don't please anything.
Yes, Lordship may record Mr. Pai.
So at the time of dictating the judgment, it is Mr. Sharma. At the time of hearing, it is Mr. Payne.
So
So whose
Lordship-
name should be recorded?
So Lordship, Mr. Pai's name may be recorded, my lord.
Heard Mr. A. Motin, learned counsel for the petitioner. Baki Mr. Payne di, baki Hindi di wo. The petitioner Khadija Khatun had been referred to the Foreigners Tribunal number
Fourth
4,
is 48.
Gwalpara, for rendering an opinion as to whether she is a person who had entered the state of Assam from the specified territory on or after 25/3/1971, resulting in registration of FT case number 306/2015. The tribunal rendered an opinion dated 31/2017 that the petitioner is a foreigner. Being aggrieved, this petition is instituted. The petitioner before the writ court relies on the voters list of,
Page 17,
sorry,
page 17.
Khadija Khatun.
Yes,
What is her 1966 of village 315 Deodhuturi, which contains the name of, who is the
Serial.
father?
serial 45.
45. Moiman Hawk.
No, my lord, serial 45, Fazal Haq,
Huh?
grandfather,
Page 17.
17.
मेरे फाइल में लिए तो
1255.
1255.
Yes. A vernacular page.
I am reading vernacular only. Serial number 45. Yes, Fazal Haq.
Serial number 45 is Moinal Haq, son of Moniruddin.
46 Moinal Haq.
Acha, 45 Fazal Haq, son of Moniruddin.
Yes.
He is the father.
Grandfather.
He relies on the voice, which contains the name of Faisal Haq, son of Moniruddin, at serial 45, and that of who is his wife?
PS 21, my lord.
Acha, wife separately. Petitioner and the voters list of
1966 also.
1966.
PS 21 Barnacular.
What was the earlier one? 1966?
Yes, 66, my lord, serial number 43 to 51, my lord. Kindly
Okay, two separately.
Yes.
मैं ताकि हेरी लिखो की लिखिलु and that of
That of 51 to 46.
don't say so many things. Who is the grandmother?
Grandmother Sokina Khatun.
And that of Sokina Khatun, wife of Fazal Haq, at serial 51.
Yes.
You may have given in two different pages, but this is one list.
In one list, my lord, containing the serial number, my lord, 43 to 51 and 51, 50 and 51 to 46. The two voter lists. One voter list, my lord, exhibited, my lord, other is not exhibited.
Anything more you want to say?
My lord, here, my lord, this voter is not exhibited before the court.
Mr. Moti, you always believe in whatever you want to say. You never believe in responding to what we are trying to ask you. I have asked you only one question. That page 17 and page 21 are the same voters list. Only thing you have given it in two different parts.
Yes. Yes.
Is it not so?
Yes.
Then yes. Then you rely on
Page 28.
the petitioner thereupon relies on the voters list of 1985 of village 110 Deodhuturi. Agorkini Thanasana Kolu, no? Deodhuturi police station question. Deodhuturi police station Lokhipur circle Balijana of Golpara district. Aru ekhonot hobo page 28. Also of village 110 Deodhuturi, which contains the name of Sakina Khatun Bewa, wife of Fazal Haq, at serial 71, and that of Razab, who is the father Razab Ali, and that of Razab Ali, son of Fazal Haq, at serial 72. Both Sakina Khatun Bewa and Razab Ali are shown to be residing in the same house number 16. The petitioner where is the birth certificate?
33.
The petitioner relies upon the birth certificate bearing serial number 0708720 issued by the Registrar of Birth and Death, Khanmuza MPHC District Golpara, which contains the information that Khadija Begum,
Khatun.
daughter of Khadija Khatun, daughter of Rajab Ali, and Fatima Khatun, comma, both residents of village Deotuturi, was born on 25/1/1990. The evidentiary value Rupa does to sound. Very good. Evidence Act concern. Secondary evidence of accept koriba na ekhon 65 or last of the contents would have to be proved through secondary evidence. So you can prove the contents to the secondary evidence. So economic contents can be proved through secondary evidence under section 65. So this is accepted. Last sentence. Value of a birth certificate had been decided by this court in its judgment dated 29/1/2019 in Rupa Das versus Union of India and others, reported in 2019 8 Guwahati Law Reports GLR 402, wherein it had been held that a birth certificate is a document covered by the Registrar of Births and Deaths Act 1969 and আচ্ছা সেখানে accept নহৰিলো আগৰবাৰ আগৰ পিছত একচেপ্ট কৰা নাই। Accept নকৰিব। Our Rupal that was not accepted. Because produced by we take under all the requirements of section 76 is absent. Nothing on demand of payment. That's for what? We are unable to accept exhibited by the is a certificate extract. In the economic to why? Converts to over. Take 64 to the one and again. Covered by the same. So let's do it now, certified copy নহয়. We have to do the certificate copy নহয়. So you prove the contents by following the procedure of section 65. You can submit for this. No.
Full stop. It had also been held that a birth certificate issued without following the requirements of Section 76 of the Evidence Act would not be admissible in evidence. And if such document is sought to be relied upon for the purpose of its contents, there would be a further requirement of the person relying on their birth certificate to adduce secondary evidence under Section 65. Now go and adduce secondary evidence under 65. As prima facie, the birth certificate produced by the petitioner, which is available at page 33 of the petition, shows that Khotija Khatun is the daughter of Rajab Ali and Fatima Khatun of village Deodhuturi, comma. And as the petitioner is relying upon the birth certificate, the matter remanded back to the tribunal to allow the petitioner to reduce further secondary evidence under Section 65 of the Evidence Act as regards the contents of the birth certificate.
The petitioner also relies on
On school certificate, my lord, in the LCR, my lord.
a certificate. You got certificate from everybody.
I'm not annexing in this case, my lord, in the
The
LCR, my lord,
petitioner
page
says
30.
that a certificate issued by the authority, the principal
Sarkarpara LP school.
of a headmaster of Sarkarpara LP school also contains the information that she is the daughter of she is the daughter of Raja Bali of village Deokhuturi. Full stop. Accordingly, on the matter being remanded back, the petitioner may adduce evidence under section 65 as regards the birth certificate and further evidence by
School of.
by rendering the evidence of the headmaster of the school through by producing the original records as regards the contents of the school certificate. And therefore, and thereafter, if the information contained in the school certificate that she is the daughter of Rajavali of village Deoduturi, and Rajavali can be understood to be a citizen through the voters list of 1985 and 1966 of village Deoduturi, wherein in the 85 list, the name of Rajavali along with his mother,
Sokina Khatun,
Sokira Khatun,
66.
and his mother Sokira Khatun appears. And in the voter list 66, the name of Sokira Khatun and his grandfather, what is the name? Din Royal.
Fazal Haq.
Fazal Haq appears. The tribunal may pass a region order upon examination. That's Baki region order. Rest of the matters, it will be listed again. With the different bench of his lordship. এটা বাকি নেই। এটা তো হয়ে গেল। এটু হয়ে গেল। এটু হয়ে গেল, এটু আছে হাকিম। 5, 6 and 7. Item 6, who would have that army man?
My lord.
What do you want to do?
My lord.
What do you want to do? You want to rely on your sentiment of being an army man who had been referred? Or you'd like to discharge your burden under section 9 and prove your citizenship?
I'll prove my citizenship. my lord.
I think it's easier way for you.
I have good document. to prove.
Need to. So when you want? Next
Anytime-
Tuesday?
Anytime next week,
Next Tuesday.
Wednesday. My friend says Wednesday. Also, I have
Wednesday.
difficult on Monday and Tuesday.
Okay.
They will come Wednesday. I might be there in. not here also. On Wednesday.
All the rest of 3 matters, some date will be given.
My lord, my lord. Deeply obliged.